Hi friends, in this video we are going to deal with the case summary of the latest Supreme Court judgment pronounced now in the area of constitution and criminal law, especially matters involving supply of illegible or blurred copies of documents relied upon by the detaining authority amounts to violation of Article 22(5) of the Constitution. To know more about the detention case, please watch this video fully. If it is helpful to you, please like, share and comment, and never forget to subscribe to it, and further click on the bell icon next to the subscribe button. In the important judgment titled The State of Manipur and Others versus BUYAMAYUM, ABDUL, HANAN, alias Aanand and another, pronounced on 19th October 2022, the main thrust on which the writ petition was filed assailing the detention order was that respondent number 1 was not supplied with legible copies of the documents relied upon by the detaining authority and took away the valuable right of respondent number 1 in making an effective representation. Further, the right to make a representation is a fundamental right, and non-supply of the legible copies of the documents relied upon by the authorities in passing the detention order is in violation of Article 22(5) of the Constitution. Manipur High Court set aside the detention order passed under Prevention of Illicit Traffic in Narcotic Drugs and Psychotropic Substances Act 1988. Being aggrieved, the present appeals have been filed. The Supreme Court has held that Article 22(5) of the Constitution confers two rights on the detainee. Firstly, the right to be informed of the grounds on which the detention order has been made, and secondly, to be afforded an earliest opportunity to make a representation against the detention order. Also, right to make a representation implies that the detainee should have all the information that will enable him to make an effective representation. This right is again subject to the right or privilege given by Class 6. At the same time, refusal to supply the documents requested by the detainee or supply of illegible or blurred copies of the documents relied upon by the detaining authority amounts to violation of Article 22(5) of the Constitution. The right to make representation is a fundamental right of the detainee under Article 22(5) of the Constitution, and supply of the illegible copy of the documents which were relied upon by the detaining authority indeed deprived him in making an effective representation, and denial thereof will hold the detention order illegal and not in accordance with the procedure contemplated under law. It is the admitted case of the parties that respondent number 1 failed to question before the detaining authority that illegible or blurred copies were supplied to him which were relied upon while passing the detention order, but the right to make representation being a fundamental right under Article 22(5) of the Constitution, in order to make effective representation, the detainee is always entitled to be supplied with the legible copies of the documents relied upon by the detaining authority, and such information made in the grounds of detention enables him to make an effective representation. Further, it was specifically raised by the respondents in their writ petition, and the reference was made in the petition referred and in the pleadings on record. There was no denial in the counter filed by the appellants before the High Court that the documents which were supplied and relied upon by the detaining authority were legible, and that did not deny respondent number 1 in making effective representation while questioning the detention order. Once this fact remained uncontroverted from the records as being placed before the High Court and the legal principles being settled, this court finds no substance in the submissions made by learned counsel for the appellants that merely because respondent number 1 failed to raise this question before the detaining authority, which go into root of the matter to take away the right vested in the detainee in assailing the detention order while availing the remedy available to him under Article 226 of the Constitution. Therefore, this court finds no error being committed by the High Court in setting aside the detention order.